convicted of first-degree murder. I'm sorry, rape. Scratch that. I've been working on a murder case for the past 2 days. Mr. Ramey was convicted of rape and a Class A misdemeanor of theft of $500 or less. On appeal, the petitioner argued insufficient evidence to sustain his convictions. He also argued that in admitting the victim's single photo identification was in error. So this court has reviewed that aspect of what is a crux of our post-conviction petition. Thereafter, the petitioner filed a timely petition for post-conviction relief and held an evidentiary hearing. Just for the record, I was not the attorney during the evidentiary hearing process. I was only appointed to represent Mr. Ramey here on appeal. In reviewing the record and the issues that were raised at the post-conviction hearing, it was of concern when the officers testified with regard to the single photo identification process that the alleged victim, obviously I understand he was convicted, but we're still of that belief that Mr. Ramey did not commit this crime, had shown up unannounced at the police station. One of the investigators that was working on the lineup for the victim to review it had answered the door with a photo of Mr. Ramey in his hand, and the victim said, "That's him." Our position is that that was suggestive, that that was an error. It also, in the full context of the totality of circumstances of the investigation of this case, we feel that it was a sloppy investigation. And as a result of that, there was a domino effect that led to Mr. Ramey being convicted of rape in this case. Our position is that the trial counsel was deficient and Mr. Ramey suffered prejudice.
Wasn't the testimony that the officer had no idea who the victim was, didn't know who was at the door, he just got up from his desk with what he was working on, answers the door, and she identifies the defendant?
That is correct, Your Honor. However, at this point, we're really focusing on what the defense counsel did not do. And I understand the court's...
I get that, but I guess now that we have the facts, so to speak, then what's the basis of how's counsel getting that suppressed?
Well, Your Honor, I think very simply the lineup was not done correctly. I know this, it was not until the trial that the victim all of a sudden then started having these very strong testimonial moments that this was, in fact, the individual. We feel that the due process of Mr. Ramey was violated at that point in time because this was shortly after the crime. And I understand the state's position is, well, that means it's even going to be more so the ability of the victim to allege this as the individual. But we also understand from the facts of the case and from Mr. Ramey's testimony that there was a discussion from Mr. Ramey in talking with other individuals about a motion to suppress. Now let's put this in context. Mr. Ramey is of a special ed level. He's at the 10th grade reading level and educational level. Mr. Manuel, the trial counsel, did not do any evaluations of Mr. Ramey, but Mr. Ramey still had concerns about how this identification took place. I think that in itself gives rise to Mr. Manuel addressing that pre-trial. The basis of that, raising it pre-trial, would have been going through an appropriate Biggers analysis. I understand the state says, well, this would have been a frivolous motion, this would have been a pointless motion, but nonetheless, it would have been a motion that I believe that the defense counsel had a duty to at least attempt with the trial counsel to look at the totality of the sloppiness of this investigation.
But having a duty to do something I'm oversimplifying it, I know, but it's the first prong.
Yes, I understand, Your Honor.
You still got to satisfy the second prong.
Correct.
And so even if I were to agree with you that this was sloppy and he should have filed a motion and was deficient in not doing so, as you analyze the actual suppression motion at this point and whether or not it'd be successful, I don't see how you get the photo ID thrown out. I don't see how you get it suppressed. I don't see where the prejudice comes. I don't see how you win, which is how you prove prejudice, correct?
Your Honor, I don't necessarily disagree with you, but I do believe that it could have changed the trajectory of the trial substantially. Looking at the record, And the failure to file a motion to suppress or a failure to challenge this identification on any level really kind of just accepted the fact that the victim identified Mr. Ramey. Now, I know the record will show that the defense attorney vigorously cross-examined witnesses and cross-examined the officers, but again, we're looking at what is deficiency and what is the duty as an attorney, a defense attorney, in that aspect. And
But yeah, but you just said it there. What is deficiency? Well, I'm conceding deficiency here. My question is, could you have won the suppression here? Because that's how you determine the second prong. He's got to file it, and he doesn't file it, that's deficient. We'll just, for now, assume that that's correct. But he has to win it, too, in order for it to change the outcome. He has to win it, otherwise you can't prove prejudice.
And, Your Honor, I don't disagree with you, but I do believe that there would have been a way, if the defense counsel had filed it appropriately and argued it appropriately, that he could have won it, even if he won it in part. The trial court would have had the ability to say, we will enter into X as exhibit or as testimony, but we will keep out Y. And the court has that discretion at that level. What's happened here is when we're looking at the totality of the circumstances of what Mr. Manuel did in not failing the motion to suppress, not properly following the avenue of challenging the single ID photograph, not doing an evaluation on Mr. Ramey, and as we argue in the brief, Mr. Ramey testified at this trial, and he was not aware that his priors could come in. Mr. Ramey had never been involved in the court system. So really, what our position is in the post-conviction prong of this case is that the totality of the circumstances of Mr. Manuel's deficiency gave rise to the prejudice that would have prohibited Mr. Ramey from receiving an adequate and fair trial.
So did the picture come in at trial?
Yes, Your Honor. There were some objections to it, but the victim testified that that's who it was, and it ended up coming in. The officer did testify at the evidentiary hearing.
So the defense lawyer at trial objected to the picture coming in?
I don't recall him objecting to the picture being introduced. He objected to some of the statements made by the officers, and he cross-examined the officers. But what raised concern with regard to the post-conviction prong of this is that essentially defense counsel just said, okay, she saw the photograph by accident, we're going to let it in, we're going to let it stand, and it just went. And unfortunately, I feel that prejudices the defendant in this case. And but not for those actions of his counsel, he would have been acquitted.
I think you were moving there, maybe you weren't. So let's talk about his right to testify and being cross-examined, and that's your second issue.
Yes, I was getting ready to go there, but that's okay, Judge.
So the trial court makes a credibility determination.
Yes.
It says, I don't believe you. If you had known, if you'd been told, you claim if you'd been told this, you wouldn't have testified. I don't believe you.
Yes.
I mean, how do we get around that?
You don't. I mean, bluntly, you just don't. I think the trial court erred in that. I think there was a lot of mistakes made in this case. In retrospect, I wish I had been the post-conviction counsel because the record will reflect that defense counsel was not even called as a witness at the evidentiary hearing. And I want to bring the court's attention to that because that is concerning. I've done this a long time, and I've done a lot of post-conviction cases, but I still feel like this court can make a determination on the post-conviction results that we're requesting. If there are no further questions, that will be all. And I did not reserve any time because I would have no rebuttal.
All right.
Thank you.
Mr. Ward?
Good morning, Your Honors. May it please the Court, Garrett Ward for the State of Tennessee. Your Honors, this Court should affirm the denial of the petitioner's petition for post-conviction relief. because neither of his claims of ineffective assistance of counsel are supported by deficiency or prejudice. First, Your Honors, I'll address what I'll call an interesting claim regarding this photo identification. I'm not sure I've seen an out-of-court identification that quite unfolded like this one did. I more or less agree with the way opposing counsel presented the facts, but essentially what happens is we have the victim of this offense show up to the police station unannounced. An officer, this is in Irwin and in Unicoi County, so perhaps not the largest police department in the state. An officer is, unbeknownst to the victim, a different officer from this department is en route to her house to go and get her, to bring her to this station for an identification. Unbeknownst to an officer who is currently at, Chief Tilson, who's currently at the police department preparing this 6-pack photo identification lineup, the victim shows up. Now, Chief Tilson isn't expecting the victim to show up alone. He's expecting this officer who's gone to get her to come back with her. So he answers the door of the police station when she knocks. Proof shows that he's holding in his hand one of these photographs that's going to go into the lineup, and the victim sort of instantly recognizes him. While perhaps unusual, this isn't something that is based on the testimony at trial, and certainly the testimony at the post-conviction hearing, which is at the very least implicitly accredited by the post-conviction court. This isn't something that's suggestive. This is sort of akin to if the defendant were, appearing in a play at a local playhouse, and the victim walks by a poster advertising the performance and sees him and instantly recognizes him. This is a photograph that to this victim is not connected to her crime. She hasn't been told that, hey, this guy's a suspect. We'd certainly have a problem if she showed up to the police station and Chief Tilson had said, hey, this is one of the suspects. But we don't have that here. We just have sort of a coincidence. She sees a photo of the defendant and recognizes him. That's our identification process here, and we're here on an ineffective assistance claim. This court dealt with a standalone claim on direct appeal, so in the context of ineffective assistance, the law in Tennessee is relatively clear. Phillips is a 2022 case from the Tennessee Supreme Court, says in no uncertain terms that to prevail on an ineffective assistance claim based on trial counsel's supposed failure to file a motion to suppress, that the very first thing that a petitioner must demonstrate is that the motion to suppress would have prevailed. We have to, my friend on the other side said on a number of occasions he thought there was a duty to at least try. Your Honors, that's simply not enough under Phillips. The petitioner must demonstrate that the motion he thinks trial counsel should have filed would have prevailed. It wouldn't have prevailed. This honestly wouldn't have even gotten past the first Biggers question of whether this was a suggestive lineup. We don't, we can consider whether it was otherwise reliable, and as I lay out in my brief, I think there's a very strong argument that this was an otherwise reliable identification, but we don't even get there because this wasn't a suggestive identification process. We really, Your Honors, it's a little unusual to analyze this under Biggers because we never get to the stage where law enforcement presents a lineup to this victim. She just sees a photograph and makes an identification. That's entirely proper, was entirely admissible, and trial counsel's failure to file this suppression motion would not have, isn't ineffective assistance because the motion wouldn't have prevailed. Turning briefly to the claim regarding the defendant's supposed unawareness of his some dangers of testifying. Judge Dyer, I think you rather hit the nail on the head when you asked how do we get past the credibility determination of the post-conviction court, and I think opposing counsel equally hit the nail on the head when he said you just can't. I believe all of us are in agreement that we have a very strong credibility determination here from the trial court. The petitioner suggested that if I had known my convictions could have been, something the state could have asked me about, I wouldn't have testified. The post-conviction court says, I don't believe you. That rather ends the inquiry on this claim. Unless this court has any questions, I'd ask that you affirm.
Thank you, General. All right. Counsel, thank you, Ms. Hyder, for taking this on appeal appointment. Appreciate your work. Okay, we're going to take about a 5-minute break and come back and do the final.
All rise. Court will be in recess for approximately 5 minutes.